All right, welcome back to the Judicial Proceedings Committee. Today is Friday, April 5th, 2024. We are on voting list 28. The first bill we're going to start off with is House Bill 531.
House Bill 531 repeals the requirement for the Parole Commission to assess a monthly $50 fee as a condition of supervision for each individual on parole and supervised by the Division of Parole and Probation. It also repeals the authorization for the division to require an individual on parole to pay for drug and alcohol abuse testing ordered by the Parole Commission and all requirements relating to the supervision fee and the payment for drug and alcohol testing.
I motion for favorable. Second. Is everyone okay with being recorded in the affirmative? All right, excellent. House Bill 531 passes unanimously. All right.
So we need to go back to 130.
So I think we voted it on the 26th, but we need the amendment to match it to the cross file, which this is the one that we concurred with, where it separated the duties for landlords with 6 or more units versus the ones with fewer than 6.
So this is House Bill 139. This is the cross file of Senate Bill 171, which is Senator Augustine. You all remember the significant amendment he came back with. What does this new amendment from the House do?
So this amendment allows for a landlord who owns 6 or more units to provide notice of utility bills, or requires that they provide notice every year during the tenancy and each year therefore, whereas the landlord that has units fewer than 6 provides the periodic utility bills to the tenant.
All right, so to bring this back, we have to motion to reconsider the vote by which the bill passed, and then it's going to be open to amendment again. So I make the motion. Is that okay with everyone? I seconded, and everyone's okay. So now the bill's before you. So this new amendment, we adopt that. Do we have to strip off anything?
No.
Before we, okay,
no,
just add this.
Add this
Okay.
amendment. Correct.
Do you have an amendment number?
Yes. Amendment 673-123/1.
All right, so I'm going to move the amendment. Is everyone okay with that? All right, now the bill's before you as amended. The motion is for favorable. It's been seconded. Is everyone okay being recorded in the affirmative? Okay, great. All right, House Bill 195.
House Bill 195 requires the Department of State Police to establish a Purple Alert program to provide a system for rapid dissemination of information to assist in locating a missing person. Among other requirements, DSP must adopt guidelines and develop procedures for issuing a Purple Alert for missing persons, provide specified training and assistance to local law enforcement agencies, and consult with the State Highway Administration and Maryland State Department of Education as specified in the bill. The bill also establishes a notification requirement for a caregiver or person filing a report regarding a missing person.
You all remember this testimony, this hearing from Senator Ellis. I'd like to move his bill if we move this as well, but this is House Bill 195. Yeah. So motions for favorable, it's been seconded. Is everyone okay? All right, and we're gonna pull up the Senate cross file as well, which is Senate Bill 817 or
817.
817 is the cross file. Same, are they identical?
Let's see. No, it would need to be made to conform.
Say conform.
You would need to conform.
The motion is to conform Senate Bill 817 to House Bill 195. Seconded. All right. Motions for favorable. Everyone's okay being recorded in the affirmative? Yes. Excellent. Okay.
Ben sent us a text on something.
House Bill 598.
House Bill 598 prohibits discrimination based on military status with regard to public accommodation, housing, employment, financial transactions, education, insurance, the provision of public utility services, and state personnel actions.
The House, they amended the cross file of this, right?
Correct.
Okay. So how is it different from the Senate version?
So the Senate version that we passed, or did we move that? I'm sorry, give me 1 second. Yeah, so they amended it just to limit the forms of discrimination to employment and housing. And that was for the purpose, there was some testimony that if military status is elevated to a protected class, federal law, federal funds could be lost.
Motions for or favorable? All right. Everyone's okay with being recorded in the affirmative? All right, excellent. All right, we're gonna go back to Senate Bill 949.
I'm sorry, Mr. Chair.
Yes.
So we just passed House Bill 598 clean with the House amendments that were already added.
That was a House
Yeah,
bill, yeah.
Yep, okay.
Yeah.
All right, we're good on that.
Okay, yeah.
And-
Thank you.
Can I just make sure the committee understands what we passed is just related to employment
Yep.
and housing discrimination?
Yeah.
Okay.
Yep.
Do you wanna just?
It took out financial transactions, education, insurance, and the provision of public utility service and state personnel actions.
Senate Bill 949, this is the bill that was on earlier. It prohibits the sale or distribution of self-administered sexual assault evidence collection kits. Violations are deemed as unfair, abusive, or deceptive trade practices under the Maryland Consumer Protection Act. In the committee's voting packet, there are two amendments from the sponsor. Just a quick note so nobody gets confused about it. The amendments from the sponsor are not the amendments that were being discussed earlier today. Those are different. So going through the amendments, we'll start with this is for Senate Bill 949, Amendment 333-825/1. That's Senate Bill 949, 333-825/1. The amendment makes changes on, if you turn to the reprint, bill page 505. This prevents limitation or waiver of rights on evidence collection kits. So specifically under line 20 provides that any agreement, condition of access or use or policy that limits or waives any substantive or procedural right or remedy to a claim against any person who provides a victim or another person with any service, product, information, or other means to collect evidence of a sexual assault is null and void as being against the public policy of the state. Further, any disclaimer of any warranties, express or implied, of merchantability, fitness for a particular purpose, or non-infringement regarding any service, product, information, or other means to collect evidence of sexual assault is null and void as being against the public policy of the state. So disclaimers, you are familiar, we're all familiar with the fine print on pretty much anything that you buy. Your iTunes service agreement is going to have disclaimers in it. Basically what this says is if there's anything where a person is waiving a right by virtue of using the product, and that's something that's, say, on the product or in the paperwork for the product, what this is saying is that that's null and void.
I don't know how it makes the bill better. I mean, it's made it worse. No, I don't.
Doesn't make it worse. So it's just there.
Maybe a more on point hypothetical. Sometimes a popular waiver term is waiving your right to bring or participate in a class action. So mandatory arbitration against a product manufacturer. So for example, if there were a waiver like that that accompanied a sexual assault evidence collection kit, it would be, what this is saying in that context is that state law would make that null and void.
That makes it better. I'm concerned. So
I don't know how that makes it better. I tend to believe, well, I haven't submitted this amendment, but it basically does the opposite. It gives that disclaimer. Meaning that it may be not, well, I don't think it's proper for me to bring it up because we're discussing this other amendment, but it does the opposite. Like if you got a pack of cigarettes and it says this may cause cancer, the way I see this amendment is saying you can't have that on the product.
Not,
But it's so relevant.
yeah, that's more of like a, so like the, I guess how I would sort of frame that, what you're describing, Senator McKay, is more like a product warning. So like on the pack of cigarettes, the Surgeon General's warning. That's more advising the consumer of a risk or a danger associated with using that product.
Okay.
This would be more akin to something disclaiming, saying, hey, there is a little bit of overlap. Hey, there's fair notice here, that that we're going to disclaim a warranty about the product, or
Can we just do this in the reverse? So like with this is the first part is saying that is if I'm a distributor of one of these products that I can't, that I'm then someone can come against me as a distributor of one of these products. Okay, so I can't have in that purchase agreement any sort of waiver of liability that exposes me, the distributor.
Right.
Okay. So give an example of someone, and the second part is a warranty of like any sort of how it's going to be used,
right,
or if it's efficacy or its admissibility. Okay, if I say, hey, look, you can use this for XYZ, it's guaranteed to give you this outcome, or it's going to give you this outcome. That's the second part.
Yeah.
Okay. So give us an example of how the first part, me as a distributor of this product, would try to waive or to shield myself from any sort of liability. What would a consumer come at me for based on me selling this product? Just give it that. I think that's the better way to kind of talk about it.
Well, I mean, if you were as the distributor were, I guess to say, this may not be admissible in court, you're using this at your own risk.
One thing that
You couldn't even waive that.
Right.
Say, even if you said that, even if you said I this is not admissible in court.
So this,
Yeah.
I think the company that makes this, from what I can tell, it's not a Maryland-based company. So one you purchase the product, and the product may say, if you sue, you can only sue in this particular state. So what this is saying is that they have no right to take the ability to use a Maryland court away from you. I mean, a lot of these companies say you got to come to whatever other state. So
Like under
that's
the
one
laws
thing
of
that I think-
Pennsylvania or
Correct.
California.
So that's one thing that I think that would fall under J1. In terms of J2, the thing that comes to my mind with fitness for a particular purpose, this kit will, the idea you're using this kit so that you can work to see whether or not you were raped. So that's the purpose in your mind. So they would try to disclaim that. So they're saying, no, if this language is in there, you can't say that it's not, that it's being purchased. You can't disclaim the warranty for fitness for a particular purpose, which is the purpose is determining whether or not you've been raped. I think they're good amendments to the bill.
Senator James.
Well, I have a question because I thought that we most definitely wanted the maker of, and there's more than one out there. We've only been dealing with one, but I've been doing some research. I thought we wanted to make sure that the maker of this kind of product clearly tells the public that it may not be admissible in court or is not admissible in court or whatever, right? And some limitations. So I am for making sure any dispute has to be in Maryland, which we can clearly say that, you see those provisions that say if there's a dispute that, this will be adjudicated under the laws of X state, but I don't think either of these amendments deals with that. But so how does it work if we want them to clearly say this is not a forensic test that, that happens in a hospital, that doesn't meet chain of custody and all kinds of other issues about this, we would want them to say that. So then you're saying that, but guess what? Even though we want them to say that, maybe we insist they say it, these provisions would say, well, I can sue you over the fact that it's not admissible in court. And so I don't know how to square that circle.
I mean,
Or if we want to, I don't know.
yeah, the more and more I think about it, and this kind of goes back to the point that Senator McKay was bringing up about sort of that Surgeon General's warning, like you're sort of doing this at your own risk. Like the pack of cigarettes, that this may cause cancer, it may cause birth defects. Right. Like you're sort of doing that at your own risk. It is sort of this nullifies any sort of warranty warning or disclaimer that the manufacturer puts on. So if you wanted, on the one hand, now to be clear, the bill as it's in these amendments and the bill as it's before the committee actually outlaws the kits altogether. But assuming that you weren't outlawing them and you were requiring a warning label on them, then you would basically, I think it would be helpful to courts in determining what applies and what doesn't, to say sort of accept as provided in these requirements. Any other warranty or waiver is null and void if you were going to do both.
So I think what you're saying is that if we were to, allow them to be sold or hold off allowing them to be sold until regulations are developed. But the way to square this language is if we do insist that they provide warnings, which I think should clearly be on these, we would carve that out and say, but for these warnings about their not being admissible or, unlikely, any other attempts by the manufacturer to, avoid liability for other issues that may arise from the use of this product would be null and void. Is that the way what you're thinking?
I think from a drafting entirely possible to sort of, as I'm thinking about it, it's from a drafting perspective, I think you could do that.
Okay.
Like you had a subsection A that said the warning needs to include X, Y, and Z,
Right.
Or it shall have X, Y, and Z.
Right.
And then in subsection B, you have language like you have here, nullifying any sort of disclaimer, but the lead-in language would be except as provided in subsection A.
And I'm assuming these amendments are being offered in the event we would follow on. We would, because it doesn't make any sense to do any of these given the way the bill originally was put in. But I assume what we're doing is if we were to not out and out ban it, but allow maybe not allow them to be sold unless and until their regulations. But in any event, whatever happens, we're not going to allow limitations on liability except for a few carve outs. Is that? Because I don't think these amendments make sense, do they, if we are banning the product? Because then, or is that how you understand this amendment?
I think other means to collect.
Because there is another provision here that says that the health department could use these, and so I assume that
and
this language would apply to that too.
Well, and I don't know if my reading of the language and the amendment, just the new language for the amendment, is that it doesn't the wording of it doesn't just apply to the self-administered kits. It applies to any any sort of kit that is designed for collection of evidence for sexual assault. At the I guess 1, 2, 3, 4 lines down. Let's see, any service, product, or information or other means to collect evidence of sexual assault. So I think that that's broader than just this self-collection kits.
Because I don't know what I found. I found on for sale these kits, but I think they might be kits the hospitals buy because they say they're there's the GSA sexual assault evidence collection kit, the GSA standard kit, and the victim sexual assault evidence collection kit. I mean, sorry, I was doing this research super fast. I kind of guess, I'm not sure what these kits are. These might be the ones hospitals buy. And if they are, I guess this warranty limitations on, you know, avoiding liability about warranties would go along with these kits. I don't know if that's what the sponsor wants us to do. Yeah, I gotta find out about these kits that I just located. They have nothing to do with at-home one I'm aware of. They're much more comprehensive. All right.
Thank you, Mr. Chair. Thank you, Senator James. So it would just seem to me, as I'm trying to understand the sponsor's amendment, I'm fine with that as long as we are going to make it a regulatory bill, but not ban bill. If we're going to make it a ban bill, it makes no sense to put that on there. So, I mean, I'll move to accept the amendments so that we can move to the next discussion.
There's a motion, second. Open motion, but Senator Forms provided that
I just want to make a couple quick comments in regards to, again, going back to the procedural application of this kit. And regardless of what these amendments are, we need to look at the idea that these kits are being provided free of charge in some places to get started with false and misrepresented type of info around these kits. And when we're looking at that, you know, I wanted to go and I checked with the AG over there, Mr. AG, I apologize, AG Brown, and 8 states have already prohibited these kits from fraudulent and deceptive practices. And when you read, you know, I'm on their website and I'm looking around, there's these kits. This is what I was trying to say earlier today. They lack the chain of custody that's required by law to be able to prosecute this. And when we were talking earlier about a choice, you know, the comment was made, well, this gives them a choice. Actually, the choice that they take, if they take this choice as the option, it eliminates any further criminal prosecution. It doesn't give them a choice, although it's being provided as an evidentiary on their own website. It's early evidence kits. They're not evidence. It can't be submitted as evidence. It ruins the legitimacy of any case moving forward. And thereby, because it says it's an evidence kit, it creates the idea that, or the opportunity for the victim to be re-traumatized because they are doing it under the guise that they should be able to have this evidence collected and they think they're doing it the right way, but then they're learning it has zero value. And not only does it have zero value in a criminal court because of how it's done, you know, when these safe nurses do these exams, they're doing them through as experts. There's a proper process, storage of the collection of the evidence and storage of it. You got to keep it from spoilage. You've got to be able to keep it safe of any cross-contamination of the person that's taken the test. So there's a reason that we have, if you will, and I mean, we have a very set procedure of this collection. To have it listed as an early evidence kit as being advertised, that in and of itself is misleading and creates the illusion to the people that they're taking something from this trauma that would be helpful later. It takes 8 weeks to get the test results approximately, and any DNA profile that's captured in there, it's not processable. They're not processing it for a DNA profile match. My concern is that let's take if we have a serial rapist who's doing things, who's out preying on our communities, and someone is potentially, they think they're a victim of this, and they take this and do it themselves, and they believe they have some DNA. But the problem is it's not admissible. It's not admissible in any criminal prosecution. So not only would that person be re-victimized, but all those others that potentially had this gone through the safe exam could have gotten justice. That misleading part should mean a lot to anybody in here, because the last thing, the Attorney General is part of the Consumer Protection Division. They're trying to insulate our consumers, our citizens, from those that prey upon them with these type of items. And when we have these type of items that are being flushed into the system at a level of the colleges and universities, and they're trying to force them in there, we should be wondering why. Why are they doing that? Why is there such a hard push on that? And the last thing is that when a safe exam is taken by the proper authorities, it's processed, it's kept in the proper contained vials and forwarded straight from them to the state's crime lab. There is no middle ground, because this is again, chain of custody. These self-administered kits, I would ask, how many times have they ever been offered successfully in a court of law? And I think we all know what the answer to that is. 0. So what I'm saying is why would we want to allow something to be that is being presented under the guise that it's an evidentiary kit, and it's being presented as such when it has 0 evidentiary value for these victims? I think we just leave the bill as it is. We don't, like you said, don't do the amendments if we don't need to, unless they're conforming to the House version, which may be part of it. But the bill is clean and it needs to move forward for the protection of our.
All right. So Senator Vogt, I actually agree with you on the amendments piece. There are a lot more.
Yeah, I mean, I'm sorry, I was on the amendments, just saying that I think we can just leave it as it is and move it clean, unless these are to codify to the House version.
So go ahead. They are, but there are potentially some significant issues with these amendments. But go ahead, Senator. Jamie, go ahead and just say your thing, because I know you have to say it for the record that this will conform this to the House version. But we're discussing a lot of the amendments. May have some significant problems, and if we do the research and it's fine, we can always add it on the floor if this bill advances clean. So okay,
leave it clean.
You and I are sympathetic on that, but go ahead, Jamie.
Sure. And just on review, the 2 amendments in your voting packet do conform to the changes that were made by the House to their version of the bill.
I was going to get representative from the Attorney General's Office of South Division again. Some feedback on the findings of your research. But I want to get Senator Sidnor and Senator Kate first.
No, I was just going to say one of the things that Senator Folden mentioned that caught my attention was how the kits are titled. If they're titled evidence, then we may want to consider. But then, if the bill is, if it's amended or something, if it goes forward as a regulatory piece, that cannot be used in the definition, because that in and of itself will be a deceptive trade practice. So that when he said that just kind of triggered that thought.
First of all, I agree with you that part of it needs to be taken off of it. But I don't agree with that these don't have any use or value. The conversation that you had, Senator Fulton, was the assumption that the victim wanted to go to court. That was the assumption. I believe there's a certain amount of people that want validation that may not want to go to court. And while they show in the data 1 out of 7 and 1 out of 5, they're not interested in going to the hospital and going to the police department, but they want some kind of a validation. Now, I didn't call my wife in the interim, but my wife is a very private person. And while I don't know, I hope that she has never been raped. I don't know that, but she would be somebody who would not want to be re-victimized by going to the hospital and reliving it. She would not be somebody who would want to go to the police department. And so I don't understand why we want to eliminate the choice for someone to make their choice, regardless of if we think it's the right choice or not the right choice. So to me, whatever amendments we do, we make it regulatory. We take out the deceptive price wording in there from an evidence standpoint, and we allow the product. I actually, as I've thought about this, I think this product should be on every college campus. I think that we should put it as more as a defensive mode to tell these, I'll call them what they are, dirtbags, you're not going. And I think it's more preventative than anything else. And we do education in our schools. We give out condoms. We give out all kinds of different things for preventative. And I think this is a preventative. If it gets to a court system, then Senator Fulton is 100% right in that it's not going to be. But my question is, Senator, when it comes to evidence, regardless of evidence being admissible in court or not, doesn't evidence help make the case to find other things? Not at all. Not at all. Please.
So the evidence that we're discussing here is a very short-lived evidence lifespan. So yes, the idea that the evidence collection process, that would be for most cases, yes, you continue to gather evidence. On a sexual assault case, there's a very short window of time that the victim would need to come in to be able to have the proper safe exam done so that the evidence collected is not cross-contaminated with anything else and it's sterile. It's taken in proper procedures. If in the example you're talking about with the option or the choice, once they've done that and they've done this kit and they go to turn it in and they wait, the process has been contaminated. The victims, the evidence that's on the victim's being is contaminated. And I guess my question is that I don't understand what you're talking about, the value that this brings back, because it's not going to give them a profile of who did it. It's not going to give them, this test does nothing to give them other than, I mean, honestly, I don't even know what the full value of it is, because it's being listed as an evidence kit, but what value do they get back out of it? Is it going to tell them that they were raped? If they're taking this kit, they've already, most already know or are highly suspect that they've been violated. So only on certain instances where there would be a blackout or something like that, where they weren't actually a participant, a willing participant, it's going to, I guess, validate that there was something there, but it has zero evidentiary value and it has zero, there is no additional evidence to be collected beyond that waiting 8 weeks.
I would concur waiting 8 weeks. If the validation was, I want to get the perpetrator put away. I don't know if that is exactly what one wants. to happen. Then why does 1 out of 5 and the 1 out of 7 do not trust to go to the court, through the hospital and go there?
We're gonna disagree on what, I mean, the stats are what they can, the stats are subjective on how they're applied and where they're coming from. We obviously want more victims to come forward in law enforcement. It's an important element. And a part of that is the community trust and rebuilding that we all talk about here and doing and continuing to foster. But a lot of the things that have been said here, even today, are counterproductive to that ideology of creating that bridge between the community and the law enforcement and the prosecutors that we have. These statements are damaging to that, and these are from public leaders. This process is not admissible. It does nothing to validate or to bring forward any evidentiary value in any case moving forward. And the potential is much higher for a victim to be re-victimized once they learn that it has no value than it is to go and seek proper medical attention.
All right, sorry, just one insert. Look, I mean, not, you know, I want to have Senator McKay offer his adjourn, and then I'm gonna go to Senator James. Just, you know, look, it's not necessary. Just to say that it's clearly not admissible is not true. Senator James, go ahead.
There with and it could be dated. I know it's 2021. This is from the state of California, and the Department of Justice, unless they've done something since, you know, did issue a warning about the limitations of these kits. They may not be entered into a national DNA database, but it says may. They do not gather some other important information. I've read about the forensic test now, I understand. And most notably to this debate about the court, it says, if evidence from an at-home kit is introduced in court, it would very likely require your detailed testimony about how, when, and where you collected the evidence. So, and I'm taking this right off of the Department of Justice from California. So I'm I get what you're saying about it probably wouldn't meet the standard of chain of custody, might not be the right lab, on and on and on. So very, very unlikely. But I'm not sure I could say with absolute certainty it would never have probative value in a court. It's up to the court to decide. And maybe they'll always decide against. Or I'm reading this, you know, this, what is it? You know, this warning, and it's wrong, and it may be wrong, but it does say that, at least in California, they think it could be admitted, but may not be successful in it being admitted. And if this is wrong, I stand corrected. I found this confusing, given that everyone's told me it'll never ever be admitted. So I'm just struggling with that.
So I agree exactly with what Senator James just said, and that's why I think this debate it's tough, because what you said is intellectually honest, and this whole thing it's not easy. It's like a complete gray area, and so also to hear the other side of that in practice and in application, I'd like to hear the Attorney General because I think what you said is intellectually right. I mean, it's exactly right.
Right. That's what
I'm gonna stand up because I'm kind of short. Rhea Harris,
Yeah,
Deputy
because-
Chief of Legislative Affairs for the Office of the Attorney General, also Chair of the State Committee. And over the past 7 months, we have done a lot of investigation, talked to a lot of people. We've done research. We found out that 8 other states have either issued cease and desist orders or warnings. The kits have not been produced in court as evidence. But I also want to put out the fact that when a person goes for a safe exam, they go to a nurse. The nurse performs the exam. They also offer health care, other testing like pregnancy testing, in case you think you were, you know, raped and you think it might be pregnancy, you might be pregnant. They also offer health care. They also offer counseling and assistance. So it's more than just testing for the DNA. And what we found out about the self-administered or DIY kits, as you say, when that evidence goes to a lab, the person, the victim, only gets back a report that yes or no other DNA was found. They don't get the sample back. the law enforcement here can't go to that lab out of state and get that sample. We don't know what status is in. We don't know if it can even be added to CODIS. So like Maryland State Police Crime Lab can't go get that sample and then run it through CODIS because we have no idea of how it was collected or what it belongs to. So that's why we get into the evidence in a criminal procedure. The other thing you have to understand is when a victim goes to a safe exam, they have the choice of whether they want anything done with their samples. So they can be stored here in the state as an anonymous kit. It doesn't have to be tested if they don't want it to be tested, but it could be there in case 10 years from now they say, hey, yeah, I want to test it. It's been stored, it's been kept in a chain of custody, and the crime lab can pull it back out and test it. Also, too, we have a tracking system that is coming online this month, end of this month, that will track all of these evidence kits. And to answer your question, Senator James, there are kits that are used that MSP orders now that are paid for by GOCAP that are used in the safe exams, and they go to the hospitals. So they aren't self-administered exams. Yeah, I was just.
Warranty, unless we changed it, would apply to the kits that you buy, the state buys, right?
Not necessarily.
Well, it is, I'm just, that language.
Okay.
Would, is my point. And so we would have to, come up with some way to make sure that we're not making it harder for you all if you all want to stand by the kits that you buy.
The kits that we buy don't come with those warnings because they go to professionals. So the kits that are DIY kits, what they're trying to do is waive the ability for the victim to sue the company about the kits. And so it was just that language that we were trying to stop.
I don't know if the kits that you buy any language about their product to you all.
No, they do not.
Okay.
All right, so we got McKay, Folden, Muse, and then we're gonna tie a bow on this and move off the dime and take some actions, because, all right, so Senator McKay, then Muse.
So, thank you.
Mhm.
So they have the choice to send the kit out
No, they have the choice of whether they want it to be tested.
to be tested.
And they don't even have to put their names on it.
Okay.
And with the new tracking system.
But then they have the choice to have it go into the tracking system.
Yes, it will go in the tracking system as an anonymous case.
Right.
And they will have ability to, a number assigned to them
Right.
that they can go in and see where their kit is in the
Right.
tracking system.
So we've mentioned 3 different places that they have the choice, but you're going to say we got to ban this product because they don't have the choice to use this product.
This product doesn't give them the health care. It doesn't give them the counseling,
But
and it
you
may
just-
not
but you
report
just
a
said that-
DNA.
But they had the choice to do all this, but now if this bill goes through, we're going to ban a product that they don't have the choice to use because it doesn't do everything that for the judicial branch to make sure that somebody gets caught or convicted. But the assumption is that that's what somebody wants to do.
Over there. Okay, in my
I mean,
response,
that's,
the bill is not about choice.
I mean, that's,
No, to be fair, I mean, that's, we have received testimony. I mean, as hard as it is to grasp, we've
I mean,
received
we-
testimony that people do things for a
we've had
multitude of different reasons and
close
don't always.
testimony.
Should I
Yes,
respond?
ma'am,
now?
please.
Okay, so the bill is not about choice. We're trying to protect the citizens of Maryland. Whether they've been a victim or not, we're trying to protect them so that they get the best health care in response for what they need. These DIY kits are not the best response, hence why we're trying to ban them.
Okay. But that's, you want to ban them.
Mhm.
It would be different if you would regulate them and tell through education. Look, I believe the first thing they need to do is go to the hospital with the nurse. Okay, I do believe that that is. But we've heard testimony that that's not for everybody. So it would seem to me that the testimony from the AG should be, we should be regulating this so it's not deceptive practices, but gives that person the ability to exercise their choice I can't believe I'm having this. I mean, it's just a bizarre.
I'm gonna rerun this, you know, that's gonna be great. I'm
No,
kidding, I'm kidding.
Literally, there goes my ratings with, you know, life. But anyhow,
But
I don't understand. Look, I don't mean this disrespectfully,
Mhm.
but it's almost like they're not smart enough, they're not knowledgeable enough, they don't understand that they're making a bad decision, and I'm gonna ban it because you don't have a right to do that.
I'm not talking about anybody's rights. What I am talking about is what Consumer Protection Division, along with the SAIC committee, decided was the best way to do it is to get actual health care. And your side of the street and the House side of the street passed a telehealth bill, which give more access across the state of Maryland for people to have exams. So there will be access across the state of Maryland.
Okay, well, thank you. I just
Sure.
disagree that we should be going down a regulatory, not a ban. But thank you.
That is not the opinion of the Consumer Protection Division.
Senator Muse,
Thank you.
Senator Muse.
Yes, sir.
Good to see you.
You too.
And pardon, I'm not as knowledgeable of this. I've been studying it. But when it comes to giving a choice, sometimes what a victim wants is just to know that I've been compensated for something that was done to me that was wrong.
Mhm.
In a criminal proceeding, if I tape you and you don't have my permission, I'm on the phone, I tape you, well, that's not admissible in criminal court.
Okay.
But it is admissible in civil court. Is that correct?
Yes.
And if a person decides, I don't want to go the police route, et cetera, but I do want to sue him or her in civil court, and this would then be allowed in civil court for a number of reasons, that the standards are not as high in the civil court, and could it then be used as evidence there?
It may or may not be. You have to understand that rapists are very smart these days, and a lot of them wear condoms. So even if you sent this test out to a Florida lab, it may not come back with any foreign DNA. So what purpose
No,
does it serve?
but one can prevail in civil court
I'm not sure.
provided A, B, and C.
I can't speak on that. I'm not sure.
Okay,
All right, so
thank you.
yeah, a little one-on-one, like same rules of evidence, different
Right.
burdens for civil and
Right.
criminal, but yeah.
Mhm.
Okay, go ahead, Senator Fulton, then we're gonna wrap up with Senator James, and then we are going to make a motion.
Thank you, Mr. Chair. Thank you for clarifying that the rules of evidence still apply.
Universally in both civil and
Universally,
criminal.
regardless of the court, one
Yes.
is not watered down. You still have to meet the rules of evidentiary value.
Mhm.
And the different burden of proof for the process. All right, so I just one of these things that, again, we're talking about is I keep hearing this choice.
Mhm.
And when you brought up was the idea that they had the choice if they wanted to get it processed,
Mhm.
fully processed by the state
Mhm.
crime lab.
Mhm.
They could have it even processed anonymously
Mhm.
and follow the tracking number with their code they were given.
Mhm.
Or they could have the evidence taken, properly collected, and stored until a time that they feel either okay with moving forward with it, but it would have been collected in a proper fashion. Is that what I heard you say?
That is exactly what you heard me say.
Okay. And so the choice you brought up was that there's actually multiple choices at the time of a proper physical safe exam to proceed from there. But knowing that whatever choice they made, all the evidence that was collected was of value that day and any day thereafter, as long as the chain of custody and the is appropriate and there's no contamination or storage issues, something to that effect. When we get into everything is in its proper vein of responsibility.
Yes, sir.
Is that correct?
Yes, sir.
The disclaimer we're talking about, they put a disclaimer on there, obviously, because a lot of these kids go to, like my good friend from Western Maryland saying, they go to these universities, younger women, younger persons, I should say, I
Yes.
apologize, younger persons. And anybody that's been involved or investigated these type of crimes, the victims face a significant trauma, not only of their being, their physical being, but they have mental difficulties processing that they were a victim, one, or just dealing with the situation because it's overwhelming. I mean, you've been violated. There is no greater violation of a person than being raped like that, and other than taking their life. So isn't there science that shows, in these studies that we've looked at, and I know there's great detail and data out there that talks about an informed decision post-trauma?
Yeah.
And informed decisions post-trauma are usually less reliable because of if they're doing it on their own, where they're having to research it on their own and do what they think they're getting with the evidence, which is what I'm talking about, versus someone that goes to a safe exam and everyone there's no instructions needed on the box because everyone's a trained expert in their responsibility. They know the rules of evidence collection, and they know how to properly seal, package, deliver. Chain of custody is solid.
Yep.
Correct?
Yes.
In this safe exam, are there not also additional things that are done to verify that there was penetration, like photographing?
Yes.
And additional exams to seek the trauma that's actually on the body, which is alluding to the additional potential healthcare needs of the person, physical and mental?
Yes.
Those are offered there.
Yes.
They're not offered here.
No.
No pictures go with these exams.
Nope.
Any DNA that's collected through the exams of the safe exam is admissible to go into the database for evaluation, right?
Right.
The national database. Okay, so I just wanted to make sure that we were all clear on what's collected, how it's collected, and the significance of that. So I appreciate your time. Thank you for the lovely gift today.
You're welcome.
Nice.
I just gave him Snickers bar.
That was just wise move. All
Yes.
right. All right, Senator James, and then we're gonna roll something.
But I read out loud from California, the various warnings they have. You don't disagree with them. For example, it says, if evidence from an at-home kit is introduced in court, it would very likely require you to, get up and testify as to the how, when, and where. You don't disagree with that, right?
No, I don't, but I want to make a clarification.
Oh, sure.
Because if it's an at-home kit or DIY kit, as we called it,
Yeah.
the victim would have to testify to all of that.
Yes, yes.
If it was a safe exam, it would be the nurse that collected the evidence.
Well, that's what he said. That's what this is saying. All right. So I just wanted to make sure that I think Senator Folden and I did the research too. I know what those forensic exams in the hospital are like, and nobody is debating or even suggesting that this other at-home kit does a fraction of that. But I just want to make sure that a lot of people are saying, it's never admitted into court, but I think that is not accurate. I think
it has not been tested.
Right. No, my point is there's no law that says at-home rape kits cannot be introduced into court, introduces evidence, might be rejected, it could be introduced, and it may be admitted. I'm not talking about a criminal case.
There's a possibility.
Yeah, that's all right. So I just want to make sure we don't overstate. I get how hard it would be in a criminal case. I just don't want to misstate the law that, they're never admitted, or they could never be evidence. And then I just wanted to ask one other clarifying question. In the bill, without being amended, it says this section does not apply to a self-administered sexual assault evidence collection kit that is issued from the Maryland Department of Health. And I am trying to figure out, that sounds like a kit that you self-administered makes me think that is something you would administer, you would use the kit on yourself. Is that what that language is referring to?
I know that that's what the language was referring to, but I don't know any case where the kits are given out by the Department of Health.
Right. But I just want to make sure that that particular provision in the law assumes that there could be self-administered sexual assault evidence kits that could be issued by the Maryland Department of Health.
It could be in the future, but it has not been.
Very good. Thank you very much. Thank you, Mr. Chairman.
Excellent. Thank you very much. That was good. All right, so. All right. What do you want to do? There's been no motion or anything. I'm asking you all, what do you all want to do? The amendments that were offered by the sponsor of the bill, I'm holding off on because we are doing some research, because I think there could be some serious unintended consequences. And if there aren't, then you can add them on the floor if this bill makes it to the floor. Senator West, so there, I got it. Senator West, go ahead. I don't want to, yeah.
I had asked Jamie earlier in the day to prepare an amendment along the lines that I suggested this morning. Did you get a chance to do that?
No, it's just regulatory language. So it would be, the amendment would be to, instead of banning the kits, would be to require the Attorney General to adopt regulations relating to the kits and provide that a person may not sell or distribute a kit that violated those regulations.
Okay, I proposed that amendment.
Is that amendment on the floor?
It just did.
Hold on just real quick. So, I'm sorry, Senator Muse, what did you say?
The amendment he talked about, we're gonna move the bill without even looking at the regulatory amendment?
No, we are making decisions right now.
And let's take a vote on that.
Just out of
and go
respect
back.
of procedure, real quick. Okay, all right, so we have not moved the bill. And there has been a motion to move it favorable clean. As it is, hold on. Senator James has something to say, okay. But it has not been. If there's no second, then the debate continues.
Chairman, I
Yes.
make a motion to move the bill.
You already have. There's an open motion. It has not been seconded yet. That's.
The one that Jamie just described.
Regulatory, yeah.
Now Senator James have a question.
To Senator West or council, anybody, just thinking about this regulatory scheme. Does it make any sense to, and I'm not sure how I word this, it would either be that this product, no at-home kit could be sold or distributed or given away for free in the state of Maryland unless and until the regulations were developed. And I guess the other thing I was worried about is, would it be regulations or would we make it even harder and tougher to say until the Attorney General maybe not regulate, but came back to us with a statutory scheme? Because regulations are a little more loosey-goosey. I'm just spitballing here about, I don't want this kit to be around or out or available unless and until we, not just the Attorney General, are comfortable that you can regulate this product. Because it may be that you can't. You know, they talk about needing a very high standard of a lab, and a lot of other things that will take a little bit of time and thought. So I'm just throwing it out about, I think the way the amendment you're suggesting, Senator West, right now almost implies that as soon as those regs come, you know, we'll be letting those kits be sold. And I'm not sure I wouldn't want to see this issue back before us in some way.
Right.
And feel that the Attorney General and the people that deeply care about this issue, myself included, but the advocates, think that the regulations are up to snuff. And so that's what I'm thinking about.
I'm sorry, thank you, Mr. Chair. There are 4 responses to that. First of all, the bill by its terms doesn't take effect until October 1st. So these kits that are being sold can be sold until October 1st. Secondly, the amendment that I had that I'm hope finds its way into language says the kits can only be sold in accordance with regulations promulgated by the Consumer Protection Division of the Department of the Attorney General. So after October 1st, if this bill's passed with the amendment, no kits could be sold but for those under the terms of those regulations. Thirdly, next year thirdly, when the regulations are proposed, the AELR committee will have a chance to review those regulations and comment on them. And finally, if we don't like the regulations and they still get promulgated anyway, next year, in next year's session, we can pass a statute which would change the regulations by statute.
So you don't think that we could just do what I just said, which is a little stronger and a little, I just think this committee should weigh in. I'm, with all due respect to the regulatory committee, and I think unless it passes, a hearing like this with lawyers and the attorney general and the advocates looking at what this language says.
I think the chair could always schedule a meeting of our committee this summer when the regulations are proposed, so we could comment on the regulations and advise the AELR committee. We could do that.
And I do. I don't think they should be sold unless and until regulations that satisfy us, which may never happen. Well, I would modify that Senator West amendment if you will.
We would have to make this an emergency.
Yes, that's what I was thinking.
Band
and
what
It's a pause.
it's a pause, it's a ban. I mean, it can't be sold
Unless
until, and regulations could take anywhere from 3 months, 6 months, 9 months, 12 months. So it's banned. I like yours better as it was. I don't want to do that. I'll go with yours as you did it. So I want to second his amendment.
Product is being sold in state now. Yeah.
They've been going unregulated, still give them the choice and all else that was needed. I don't see the difference.
Look, I'm not pushing one way or another. I want to hear what folks have to say with this, but like, if you feel as though a product needs to be regulated, why would you then create a pocket of time in which they were distributed unregulated? So if you're going to do that, the way to do that is to put a pause until the regulations are adopted. If you want to go that way.
Too many rapes occur in a 12-month period. I'm gonna go with your amendment. Give them a time.
It seems to me that issues are separate. The first thing we should decide is, do we want to go this route? And then the second question is, do we want to make this an emergency bill as opposed to a normal bill?
My advice would be to make it an emergency bill, but.
That's fine. I'm happy to do it.
So what do you want to do?
Vote the amendment first. West amendment.
What is the amendment you're offering? Read it again.
Read language to the committee. So the new prohibition language would provide that a person may sell, offer for sale, or distribute a self-administered sexual assault evidence collection kit only in accordance with regulations adopted by the Attorney General under this section. Then you would require the Office of the Attorney General to adopt regulations to regulate the self-administered sexual assault evidence collection kits.
I want to just be clear that his amendment, thank you, I'm sorry. I just want to be clear that Senator West's amendment would not create a pause that for these items to be distributed throughout the state, that they would be unregulated until such time that is done. Is that correct?
So by itself, the language that I just described and would still leave that unregulated if the
It's I just need yes. Is it yes? Yes, right?
So
Okay.
if you're going to go this route, you really do need to pause it
We'll come back and we'll just.
Okay, so
Down and do the
We'll
proposal.
vote this one up or down, but then come back and vote on that.
why don't you just do it together? Or else, I mean, if you're gonna do this,
So
like,
I
do it
amend my-
right. Like,
So I amend my proposed amendment to include a provision that this is an emergency bill.
I just want to clarify that I think it should be unless and until, and I don't want to, I just think the Attorney General may not come up with any regulations, but in any event that he may find that he can't regulate because it's just not acceptable, but I just want to make sure that if we do the emergency language, it becomes immediate and, right? But here's the other thought I had. Maybe I'm splitting hairs and overthinking it, but this language implies that the Attorney General will find a way to regulate this. And I'm not sure if that, it may come back with something that says they can't. It's just too, the science isn't there, the protections aren't there. So, but I don't know if anybody ever says unless and until in a statute. You may say, look, this doesn't work like that. You can't do it unless and until,
Right.
or whatever
just roll.
appropriate
Okay.
language would be.
Right. This is an open amendment. Just,
Add on, giving them up to 6 months.
yeah, that's what you'd have to do. You'd have to put a deadline,
So
but
add it on that language.
we have the benefit of having the presence of the Attorney General in the room.
Well, it's
And so,
Yeah.
we can ask the Consumer Protection Division if that is some, I mean, if you care to weigh in, I would offer you the opportunity to weigh in. If not, that's just fine.
Thank you, Mr. Chairman and members of the committee. Certainly, we can promulgate regulations and we can move out expeditiously. We've got a SAKE committee. They've studied this issue. They know this issue. You've heard from Rhea Harris. Them coupled with consumer protection that has experience in promulgating regulations. We can do it. What we won't be able to do is to regulate a ban. That you can only do. We can regulate sort of what notice looks like, what the requirements are, a review by the Consumer Protection Division and things like that. So we can do that. We can regulate how it comes to market and things like that. But a ban is only something that you can do.
Real quick, thank you. Mr. Attorney General, through your review of this process under the Consumer Protection Division, would there be an opportunity at its conclusion with all the research that's already been done and the additional that'll go into it for your office to make a decision or an opinion, maybe back to us to say, look, these would not be admissible under current laws of evidence or something to that effect, so that we would then have a better maybe path moving forward if we chose to then.
So what I'm hearing is perhaps a recommendation that, I mean, let's say, for instance, you have that language that pauses. You have the language that says promulgate regulations, and that's not going to happen in a month or two or three. I mean, there's the Maryland Administrative Procedure Act. We've got to go through a process. You could also include in that, while we're doing that, to come back with recommendations regarding or analysis about admissibility and all the other issues that you have discussed today. So we can certainly do that.
That's exactly what I would.
That's the other.
appreciate.
So I mean, look,
Thank you.
a couple of
Thank
us
you,
on this
Mr.
committee
Agee.
sit on the ALR committee. The regulatory process takes some time. Because you gotta convene, you gotta do it, it's gotta go through ALR, it's gotta have notice of comment, there's a period, there's gaps of time between each one. How long does anyone know? I should know this, but I don't know this. How long does the regulatory to adopt regulations and approve them take? I know then you have to have notice and comment, then you gotta.
It's a lengthy time. I mean, you may very well be back in session before regulations are promulgated, right? Because you got proposed rules, you got notice and comment, and then before you go to final rules.
1 year.
And
I'm gonna do a year, say a year. So you understand there's a pause for a year and then you have to. So Senator James.
I don't think we would have to put this in statute, but I do really want to ask you that the Attorney General come back to us so that we have a hearing or briefing or something on these regulations, because there's a lot of intense feeling about all of this, and I know the process works in another track, but I feel like it's really important that we would hear from you.
Yeah, like an interim.
Yeah, something. Would that,
We have the ability to ask for a hearing. So us members will ask when that comes up to actually have a hearing on these regulations, which will then that hearing will be
invite us?
invited for the JPR as a whole to come with that. So that'll take care of that issue.
There's no time limit. It's just until those regulations are promulgated.
I think that's fair.
Yeah.
We don't need to tie his hands. I think we're good, Mish.
As far as drafting and you know, you guys tell me if this works. How it would probably be easiest to draft it would be to essentially use the language of the bill now that is one section that goes into effect as an emergency act that would ban them from the time that the bill goes into effect. And then a second section that becomes effective and replaces that as soon as, yeah. Can I just ask a question for the committee? So the regulations adopted by OAG, I scratched this out and I just presented to the committee, would also include requirements for items to be included in a kit, transportation and storage of kits, and testing of kits. Does that? Okay.
I move the amendment.
It's been a motion. Senator James has seconded. We're gonna do a roll call on the amendment, on adopting the amendment. So Senator Sindor.
Just to be clear, this amendment is what you just.
Yeah, would you like me to read?
Please.
Okay. So the this is gonna require some drafting on my part, but it would establish a regulation requirement. OAG would be required to adopt regulations. Those regulations, excuse me, must include requirements for the items to be included in a kit, transportation and storage of kits, and testing of kits. A person may sell or excuse me, a person may not sell, offer for sale, or distribute a self-administered sexual assault evidence collection kit in violation of those regulations adopted by OAG. The bill would also be made emergency. So it would go into effect as soon as it received the necessary votes in both houses of the General Assembly. The language of the bill would effectively ban the sale of the kits up until the point that OAG had developed the regulations. Once the regulations are published in COMAR, then a new section of the act would go into effect, which would do what I had just described about prohibiting a person from selling, offering to sell, distributing in violation of those regulations.
Motion's been made. It's been seconded. We're gonna do a roll call.
Mr. Chairman, I'm sorry.
Yes.
But what I didn't hear in the regulations was a regulation regarding disclosure and notice. Did you?
I did not.
Because that's key. That's what the whole debate was about. You've got to have a regulation that talks about what does notice look like, packaging, marketing. So you got to have that in there. Sorry for the interruption.
Sure.
Yeah.
Everyone understands? Yes. All right. The roll call.
Vice Chair Waldstreicher.
Thank you. If I could just have a moment, I know we got to get to the floor.
We got one more piece of business to go to the floor, so
Okay.
wait.
Understood. No, I just want to say, I think this is the best of JPR and I love this committee. I am surprised sometimes at the vehemence with which some advocates come in front of us and say, I'm definitely right. The other side is this is a really close call. And I think what you see today and will continue to see as we debate this issue is people struggling to weigh the pros and cons, both on this amendment and on the underlying bill. So it's a long way of saying thank you. It's a long way of saying how much I appreciate the work of this committee and a kind of a larger commentary about how we work. So with that, I'm a no on the amendment.
Senator Sidnor,
No.
Senator West,
Yes.
Senator Muse,
Yes.
Senator Folden,
Yes.
Senator James,
Yes.
Senator Charles,
Yes.
Senator Kelly,
No, thank you, though. I appreciate it.
Senator McKay,
Yes on the amendment.
Senator Carter,
No.
Chairman Smith,
What is he wrote?
6-4.
So looks like it carries 6-4. Now the 6-4. The motion is for a favorable. Roll call.
Vice Chair Waldstreicher,
Yes.
Senator Sidnor,
Yes.
Senator West,
Yes.
Senator Muse,
Yes.
Senator Folden,
Yes.
Senator James,
Yes.
Senator Charles,
Yes.
Senator Kelly,
Yes.
Senator McKay,
Yes.
Senator Carter,
Yes.
Chairman Smith.
Yes. All right, passes Senate Bill 949 passes with amendments unanimously. We should bring up the House version. The House cross file. Yep,
Do you know what the bill number is?
it should be
Senate Bill 9, House cross file is 1047.
1047.
House Bill 1047.
All right. House Bill 1047, the motion is conform it to the Senate version, which we just passed unanimously. All right. Is everyone out? All right. All right. All right, we've got one more piece of business. Shamari House, what's the House bill or the Senate bill? 680, House Bill 680. Senate Bill 680, and we're gonna just give our Attorney General an opportunity. I know he's got an expert here, experts here. We're going to just provide you all some opportunity to kind of provide some context. This is a special situation given the Francis Scott Key Bridge. So we should take action here quickly, but I want to give the Attorney General the opportunity to kind of give us the context, and then we'll kick it back over to Shamari after the committee's had an opportunity to ask some questions.
Committee, we were here before you about 2 months ago on a bill we called UCATA, Uniform Contribution Among Tortfeasors Act, generated a lot of interesting discussion and debate. You didn't pass it. The House didn't pass it. It did not cross over. We're in a different environment today. As we all know, 2 weeks ago, the Key Bridge collapsed. It was damaged. I have authorization from the governor to hire assistant counsel. I am going to hire a law firm, and we are going to sue those responsible for the damage of the Key Bridge. That's our responsibility. I've got the authority to do it. I'm going to do it. I'm going to launch an investigation, and just based on open source. So I'm not talking about anything that I know that you don't know, but I'm going to be looking at everything from the person that pumped the gas into the ship to the owner of the ship and the 20 different people and entities in between. We're going to file a lawsuit. I have no doubt that is going to have multiple defendants. And when we finish our investigation, we're determined that some will have small liability, some will have huge liability. Under Maryland's law, when I reach that point, and I try to settle out with those small defendants, I run the risk of losing the opportunity to recover more fully from the large defendants. You heard me talk about this with my experts 2 months ago. Put it in the context of the bridge. 500 million to over $1 billion. That's the number that's out there in the ether right now about what it's going to cost, right? Repair the bridge, salvage, you name it. No one thought about infrastructure damage 2 months ago, right? No one thought that we'd make an affirmative action to recover damage to a state infrastructure like this. That's why we're back. We need your help. I can bring the lawsuit, but without this bill, I cannot settle it in a way to recover fully for the people of Maryland. I didn't even use this as a hypothetical 2 months ago because I never imagined we'd be talking about the destruction of infrastructure of this magnitude. So I'm asking the committee to favorably consider it. And I've got experts here, Julie Cuspa. You remember she was here before. Your counsel can walk you through the amendments. The amendments that you'll hear, many of those amendments we drafted before the Key Bridge. We were listening to what you said, and we clarified the language. You asked about burden of proof. You asked about determinations of liability. You asked about, I think, questions about causation. You didn't like the term, and I understand public welfare action. That's out. It's very specific, the actions that we can bring. So these amendments respond to your concerns, the concerns in the House, and now the collapse of the Key Bridge. So with that, Mr. Chairman, I'll turn it back over to council, and we're here to answer whatever questions that you have.
Excellent. Okay, so unless you all want to explain the amendments, or do you want council to do it, or, you know,
We can do it, Mr. Chairman.
Let's go ahead and have you all do it. If you could come up to the podium, that's okay. And then we'll, council can clarify anything we need to clarify, and then we'll kick it over to committee for questions. And
Good evening, everyone. Tiffany Clark, Office of the Attorney General. These amendments are largely clarifying, and as Mr. Attorney General said, they took into consideration all the concern, well, not all, but most of the considerations from the JPR and the judiciary hearings, took out the definition of public welfare action and clarifies that this bill only applies to damages to infrastructure, environment, and natural resources of the state. It also clarifies that the fact finder is in fact only a judge or a jury. It is not the Attorney General. And the bill also clarifies that the bill may not be construed to create a new action, to alter the burden of proof, to alter the causation standard, or to change any elements of an action. So, and again, these are all were concerns that were heard at the JPR and judiciary hearings, and those have been changed.
Thank you, Mr. Chair. I think I may have been one of the ones who asked questions the last time the bill came up. And that's because I'm involved in an insurance defense firm. Many of the attorneys in my firm deal with joint tortfeasor issues frequently. It is a very complicated section of the law. But having talked to the Attorney General this afternoon, I'm satisfied that you all have familiarized yourselves with the issues. You know what the issues are, and you've addressed the issues. So that being the case, I'm happy to support the bill as amended.
any further questions from the committee? Senator Fulton.
Thank you. Is the amendment written up, Mr. or someone for the, I know you said about this, the public welfare action and the public welfare claim.
Yes.
So, and then, okay, if that's the case, I'm
Written amendment, you have written amendments. Well, we don't have an interlineated version, but there are written amendments that are available to committee council.
That removes that part.
Yes.
Okay.
Absolutely.
And then the last thing I have is there any issue with this moving now, even though the Key Bridge happened 2 weeks ago? I mean, does it cause any problems at all?
Not at all.
Beautiful.
It's not commenced an action.
Beautiful. Thank you.
Sit down.
Here, I'll give you this.
Here, hold on, let's give Senator James a second here, and then
Can we get a?
Senator, all right, Shamari, you have them in concept, right?
Yes.
So you can get Shamari real quick.
I placed a rush on it after speaking in the back with the chairman. It should be finalized any minute, but it's in process.
Give me a second. Are you able to check in the system? I know you put a rush on it, but does it have a number assigned to it?
Yes.
Okay, so then you can record the number, can you not?
Yeah, I just need a second.
Okay, excellent. Just give a second. Yeah, sorry. Senator James, yep. Oh, is it off?
As hyper-focused on the litigation of the Key Bridge. Because I don't want to hold you up. I also want it just to be for the complexity and multifaceted aspect of that and not worry about whether we've given you authority that I'd have to contemplate. I don't want to slow it down, but I want to know some assurance that this is really to help you with the Key Bridge litigation. That's really what this
Absolutely.
is, right?
Yeah,
And we can-
absolutely. I wouldn't.
Take
I-
up another bill, another day on what you wanted originally and all
We
that.
were not
right?
going to come back and, you know, we heard what you did, you know, and it didn't pass and cross over. It's focused on infrastructure. We know that there are some environmental issues out there in the Bay. We don't think it's going to be huge environmental. We know that there are natural resources issues that are going to be implicated in the Bay. We
Right.
don't think those are going to be the largest.
Right.
The infrastructure will be. So this is really hyper focused, to use your language.
Thank you.
Yes.
All right.
Last question is, I know you said that you can commence with litigation now, but I mean, does this need to be an emergency bill? Can you get it?
If I got a June effective date, that'll work. I mean, by the time, you know, we can work. I mean, I'll take it as soon as you can give it to me. Yeah. I mean, I'll take it as soon as you can give it to me. Yes.
I'm just making an emergency bill. Yeah.
Mhm.
Okay. If you could just read we can adopt this in concept, but she has the number for the record. So Senator West is gone, but I'll make a motion to adopt the amendment in concept. Second. Is everyone okay being recorded in the affirmative? All right. Now the bill is before you as amended. The motion's for or favorable.
Second.
Second. Is everyone okay being recorded in the affirmative? Okay, that completes. Okay, that completes our business.
I've been told that you guys, everybody else is waiting for the.
They're waiting. All right. Sorry.